Good afternoon, viewers. My name is Abdul Nasir from the law firm of Fatuma Nassir and Associates Advocate, and I wish to welcome all of you to Court Helicopter News for the next analysis on a number of issues. It's an extreme privilege today to conduct this interview to highlight a number of issues within the the law concerning Muslims. Generally, we are going to speak about the Kadis court. What is the function of the Kadis court? What is the law? What is the law saying on issues of the Kadis court? Let me begin by our constitutional dispensation. Under the Kenyan 2010 Constitution, the Kadis court is provided for under Article 170 from sub-article 1 to sub-article 5. And the main points here are, what is the function of the Kadis court? One, the Kadis court is usually involved in interpreting personal law regarding Muslims. That is one, inheritance, marriage, divorce, and personal status. Who is a Kadhi? A Kadhi is a judicial officer who presides over matters related to persons who have professed or who are professing Islamic faith. Then there is a Chief Kadhi. A Chief Kadhi is the overall head of the Kadis court system. What are the process that the Kadhi does within the mandate he's given by the Constitution? One of the functions the Chief Kadhi does is to supervise these other Kadis courts, and he keeps record of marriage certificates, divorce certificates, which are to be transmitted to the office of the Honorable Attorney General. So currently, as we speak, we lost the former Chief Kadhi, that is Sheikh Abdul Halim Athman Hussein. We continue to pray with the family, and we say, may Allah grant him Jannah and a peaceful life in the hereafter. So there are a number of issues that the former Chief Kadhi, the late Chief Kadhi, did exceptionally. One of those issues is the visibility of the Kadis court. Through the media, we could see he had a Twitter handle. He used to engage with members of the public to ensure that the visibility of the Kadis court is not lost. He made a lot of tours to different stations to ensure that, to assess the general performance and to look into maybe the challenges, because he's the head of the Kadis court system. So currently, the Judicial Service Commission has advertised this position. It's only one position. There can only be one Chief Kadhi at a time. So some of the qualifications that the JSC will look into are the soft skills, of course, that come on board, communication skills, looking at problem solving. And it will be an interesting session to see how the Judicial Service Commission integrate their questions on matters related to Kadis court. And one of the key elements the JSC is looking at is the 10 years experience. And this experience has to deal with a number of fields, but they have already said in the advertisement that if someone has a progressive education level, it might be an added advantage. Holistically, there are a number of issues that we, as practitioners, we have seen at the Kadis court. So currently, the judgment that was delivered by the Supreme Court of Kenya, that is the Fatuma Abdul Faraj. This is a very interesting debate that has been there online. Practitioners before the Kadis court, commentators, academic, have made a significant contribution in the public debate. So this case draws identical specific issues that are in the public domain. It is critical for viewers to understand that people who profess the Islamic faith always appear before the Kadis court to ensure that their matters are resolved amicably, whether it is a matter of divorce, marriage, or inheritance. So in this case, Fatuma Abdul Faraj approached the Kadis court. However, before the matter was fully adjudicated at the Kadis court, there was a petition that was filed by one of the alleged wives of the late husband to Fatuma Abdul Faraj. So the file was consolidated at the High Court, and a number of issues arose at the High Court stage. So the High Court of Kenya, handling this matter, looked at the critical issues of Islamic Sharia, and it did recognize that Fatuma Abdul Faraj as a Muslim, and she had submitted to the Kadis court. In the analysis of the High Court made substantive directions or orders through its judgment that Fatuma Abdul Faraj and her children were allowed to inherit their late father's property. Also, the petitioner was recognized to be a valid wife, even though the question of the inheritance by her children was not directed by the High Court. So the appellant, having the Fatuma Abdul Faraj, further went to the Court of Appeal and argued the issue of her rightful access to the wealth, and also consistently submitting to deny the children of the wife, the second wife now, their access to their father's property, arguing that Islamic law disallows children born out of wedlock. And here allow me to put things into perspective. One, the Islamic law does not discriminate these minors. In fact, the most condemnation is always upon the parties involved to this process. And that's why there's a recommendation of issues to do with wills within Islamic law. My colleague will address that substantively on the qualifications of what a will within the Islamic Sharia is. So the Court of Appeal picked two fundamental constitutional articles, that is Article 27 and Article 53, relating to issues of discrimination and matters children rights. So the Court of Appeal arguably made its judgment to say that denying minors who are born out of wedlock is denying them their constitutional right not to be discriminated and to be protected from any kind of discrimination. So the appellant was not satisfied. She moved to the Supreme Court of Kenya. And here, now this judgment that was delivered by the Supreme Court recognized Article 24, sub-article 4, which allows leeway for persons professing the Islamic faith to continue to be disallowed within those conditions made in that article. So the Supreme Court of Kenya, having analyzed that article, went further to make analysis of a purposive approach, a holistic interpretation of the Constitution. Last but not least, the Supreme Court made its pronouncement that these minors are entitled to access their late father's wealth, whether they were born out of wedlock or not. So the matter has been transferred back to the High Court of Kenya for distribution even the second wife, who was recognized by the High Court. The High Court has been directed to issue joint letters of administration. So this judgment has elucidated a lot of debate in the public, and now some of the recommendations practitioners are making is that when courts of law, especially now the Court of Appeal and the Supreme Court, faces such crucial and weighty issues with regard to Islamic matters, the Chief Kadhi can openly be consulted to make an opinion on that issues. So with such a judgment, one of the recommendation practitioners have made is one, the Chief Kadhi, being the head of the Kadhi's court system, is a critical player, and maybe for some reason, because remember, when someone comes from the Kadhi's court, maybe he or she is not satisfied with the judgment of the Kadhi's court. Someone moves upwards to the High Court, and at that High Court stage, it is critical to note that the Chief Kadhi sits as an assessor to guide the court on matters Islamic law within the purview of the appeal. So one of the recommendations commentators made and practitioners is why don't we have the tripartite system from the High Court to the Court of Appeal and the Supreme Court, whereby such issues that are facing the practice of Islamic inheritance, the Chief Kadhi is consulted widely, and that's where we are simply saying that the Chief Kadhi still remains a critical office holder within the Kadhi's court system. Another cross-cutting issues relate to issues of children. We understand that within the Kenyan legal system, we have the children courts that sit widely in many parts of this country, and the Children Act defines the issues of custody and maintenance of the children, or rather a child, within this legal system. So look at a situation whereby two parties who profess Islamic faith have gone to the Kadhi to seek for a divorce, whether it's a divorce by a consent or whether it's a legal battle. So when these parties want now to request the court to give orders on issue of custody and maintenance, and remember the Kadhi's court, the practice and procedural rules identify these issues of custody and maintenance. And if you do your good research, you'll find some Kadhis have been restrained a bit to issue these orders considering matters custody and maintenance. But all in all, same practitioners are recommending that why don't we just allow the Kadhi's court, because these are issues of incidental. Once you pronounce yourself on the divorce, let us give the parent of the child within that context the opportunity to look on this. So these are cross-cutting issues. As practitioners, we have seen a major challenge at the Kadhi's court. Another issue I'd like to pick up is the issue of certificates. Let's say today someone has done their research or has been persuaded to convert to become a Muslim. We know there are different centers in Kenya that issue the conversion certificates. So I hope as recommendations, the next Chief Kadhi who will come on board is going to have a consensus to have a uniform conversion certificate that is going to keep the record of every person who has converted to become a Muslim in the records of the Chief Kadhi. And those issues highlight what the Kadhi's court system is, and the incidental issues arising. But I believe within the framework of our constitution, there can be a harmonious understanding of how the office of the Chief Kadhi is going with other stakeholders to ensure that we have a harmonious way of handling such scenarios. Yes, I believe the viewers will benefit from this discussion. Thank you for your time and have a blessed afternoon.